separation between employers and employees. Can it be mutual? Can both the employer and the employee agree to separate? That is our topic, mutual separation agreement. Welcome to the law, HR, and all the drama. So Jane, mutual separation agreements sounds fanciful. What do you think it means from a HR perspective?
When you talk about mutual separation, is when one of you is not able to work with the other, and therefore one party initiates the separation. And we call each other to a table and discuss and agree. I feel this is not working for us. Can we just call it quits? At the same time, because my contract is not ending and maybe you're the one who wants me to go, then now we have to sit and discuss the terms of this separation. So we mutually agree on what exactly should we have on the table for me to say I can walk away. So one of the things that has to be when you say mutual is that it cannot be coerced, it cannot be forced. It has to be voluntary. You must convince me if you're the one who wants me to exit, then you must tell me, you know what, in this business, I just feel we can't work with you as an employee because of the following. For you to exit, we are going to table the following. If it's agreeable to you, go think and come back. Now that is mutual separation, but sometimes it is highly abused. So happy we are talking about this. Back to you, Stella.
But I'm curious, can the employee initiate a mutual separation?
I have seen that. I've seen where people come and say, like one recent example I would give is a place where we were supposed to give someone that was very senior to put them on a performance improvement plan. And they said, guess what? For my 20 years of experience, no one has ever questioned my experience or my competency, and therefore this is not going to be a first time. I want to mutually separate.
Often what I see is employers who are trying to push the employee out. And it then goes against the term mutual separation agreement. Because the first word that comes is not separation agreement by itself. Separation is one thing, but it must be mutual.
Yeah.
And mutual, from my understanding, is that the employee agrees and the employer agrees. It must be amicable. There must be a written document. That's the word agreement. And they are agreeing to do what? To separate, to leave each other. But now often at times when it comes to my desk as a lawyer, and often at times it's because the employer has been taken to court, it's because you find that the issues that you have just mentioned, was it voluntary? Or were they trying to fire me and circumvent the Employment Act? Were there valid reasons around it? Was it a way because the new CEO or the new management did not like me? So they decided, instead of actually finding ways of finding the actual process towards letting me go, let us go the convenient route on just letting you go, giving you a package, so that then it is much convenient for us.
Yeah.
But often at times when it comes to my desk, what does it come back as? Comes back as constructive dismissal. It comes back as I was fired and forced to sign this agreement. The context around the workplace was so hostile that I had no choice to actually sign this agreement. And I've seen several cases around it, but we shall then talk about it. But I think what was very important for us to take away from this particular session is that if your employer is telling you, sign this agreement, but you do not think it's voluntary, you're being coerced. If it's not on paper, please do not accept it. Also for the employers, what would you tell them?
So for the employers, I would advise us to stop being reactive. So there are times I don't want to work with Stella at all. I do not want to see her. And therefore we say, you do what you have to do, but I don't want to see Stella. If you want to pay her the whole contract, just pay her and let her go. So that reactiveness of saying that the person has to be separated. And of course, now people know their rights. So I will still maybe sign or even refuse to sign, or I could even be seeing a lawyer as an employee. And my employer doesn't know that I'm actually being guided. So at the end of it, I will be separated, yes, but then I end up with a legal thing and take you to court because then we did not, it was coerced. It wasn't a mutual separation like you are calling it here. We're just labeling it as mutual separation. But if you look at everything else, and I'm sure you look at those cases, like there's one case that I saw where this organization called someone. Actually, the person was in school and they were told, just come back. It's very urgent, come back. When they went to the office, they found the HR director seated and the CEO, and they were given a mutual separation agreement. And they were told, we have looked at the kind of work that we are doing and we feel our metrics are going down and therefore we just have to separate. and they were forced to sign. It was within minutes. I think within 15 minutes she had signed the agreement. She was not even given time to even read through and just
process it.
Yeah, even she actually even asked for more time. Can I take 2 days to think that she was told no? By the time she was saying no, a message had already been sent. We are doing away with this particular role because of ABCD. So by all means and standards, that was being separated. It was being fired. It wasn't a mutual separation. So regardless of how much they give this particular employee after all that, when she went to court, I think she did not even need you. She would have just got with me as a HR. I would have represented her and she would have still won, because then it was such a straightforward. Because then for sure it was almost like being fired without any hearing, without following even the minimums of what the labor laws provide for. Yeah, so as we call the mutual separation, we have to always know when you're just putting a bandage, a label on something that is not a mutual separation.
And Eugene, it is interesting that you say that, because I met a CEO recently. And one of the things that the CEO said was, I have discovered this wonderful thing, because he had just joined this organization. It was not performing well. And one of the things that the board had told him is to get rid of the underperformers, or what we call the boat drillers, or who just take the boat down.
Yeah.
And he told me, I just found this wonderful thing called a mutual separation agreement. And he asked me, have you heard of it? And I said, yes. And they said, I've been dishing them out to all the underperformers and they're signing it. And of course, I gave him a word of warning, because I could tell he was overly excited that he does not have to go through a disciplinary process, which often at times takes a long time, particularly where you do not find that this employee necessarily has done anything.
They don't have an offense per se.
There's no offense. They just do not perform. And you do not want to put them under any performance improvement plan. You just want them to go and bring the performance so that then you as a CEO can look like you're performing. But you see, with such a CEO, I thought to myself, my goodness, the number of cases that will come out of this.
Mm-hmm. And sometimes it's because they have a different legal background. Like in some countries, you find that employment is at will. You can actually call someone, and because it's at will, then you just separate. But in Kenya, as much as it's at will, you really must have a valid reason, and there must be a process for letting someone go. So when they come from a different country and law, sometimes that gets them confused. And therefore they'll just call you and tell you, know what, we want to separate, we want to pay you the contract ABCD, or we want to pay you 6 months. But what they forget is, the moment you have formally employed me, you need a good reason for you to be able to separate me. So what you're saying is very common. I've seen it. And sometimes you realize that HR does not have the other processes. You're saying I'm not performing, but I don't have KPIs. We don't have a performance management system that works. Or maybe my boss has been giving me exemplary. So if you look at my records, I'm actually a very good employee. But here you are trying to fire me on performance grounds, but you have no grounds per se.
Yeah, so just one more story. And this is actually based on, and you told me today morning, you read the case that I handled. And it's actually published, where this particular employee was given a mutual separation agreement. And when they came to me, I told them that you are actually fired. It's just that you were given a document to sign. And I'll keep going and referencing this case because it's one of the latest cases. I think I got a judgment just the other day. One of the things that the court said, because in their defense, they said, the reason we gave this person a mutual separation agreement was because they were not performing. They had disciplinary issues. They were not leading the team. And the court asked itself in the judgment, if this person was such a bad employee, why give them a mutual separation agreement as opposed to taking them through a disciplinary process?
Yeah.
If they are such a bad employee, that you'd have taken them through a disciplinary process. You cannot come to court now after you've given them a mutual separation agreement and say that it's because they were a bad employee. Yet there's no proof of the same.
Yeah.
There's nothing on their file showing that you gave them warnings.
Yeah.
It's just that you want them to go. And the court stated that that mutual separation agreement was unlawful and this person was actually unfairly
terminated. Yeah.
So, folks, that's all we have on mutual separation agreement. You've now understood and it has set the foundation of what it is. In our next conversation, we're going to discuss, is it lawful? We hope to see you next time.